Good evening. My name is Frank Bannon. I'm the head of the International Arbitration Group at Clayton Utz. It's my pleasure to welcome you to the annual Clayton Utz and University of Sydney International Arbitration Lecture. I extend a particular welcome to their honours in attendance this evening. I'm joined by Professor Brown, Professor of International Law and International Arbitration of the University of Sydney, and by our speaker, Mr Moollan QC of Brick Court Chambers. We're proud to acknowledge that this is the 20th anniversary of this annual lecture, which coincides with Australian Arbitration Week and forms part of a series of events that promote the study of international arbitration and international dispute resolution. Although we are not in the same geographical location again this year, the lecture's significance and its reach is enhanced by the use of technology, which will also provide the opportunity to connect with colleagues throughout Arbitration Week. With the globalisation of investment and the increasing number of parties involved in complex projects, there has been an increase in disputes giving rise to parallel proceedings, which can cause inefficiencies and unsatisfactory outcomes. Our speaker will explore these themes in tonight's lecture, Parallel Proceedings in International Arbitration, Theoretical Analysis and Search for Practical Solutions. Our speaker, Mr Moollan, received a first-class law degree from Cambridge University and mathematics degree from École Polytechnique, Paris. He was called to the English and Mauritian bars in 1998 and took silk not long after in 2016. Today, Mr Moollan is one of the preeminent advocates in high-profile investment and commercial arbitration disputes around the world. He's acted as counsel for states and investors alike and appeared in some of the most significant ICSID arbitration cases, including White Industries in India, Can Energy in India, and Philip Morris in Australia. Mr Moollan has also made significant contributions to the practice of arbitration through positions in various leading international arbitration institutions. He's a past chairman of the United Nations Commission on International Trade Law and its Arbitration Working Group. He became the youngest vice president of the International Court of Arbitration of the ICC in 2009, a position he held for 6 years. He's a past member of the LCIA Court. He's a current member of the World Bank's ICSID panel of arbitrators. He's a visiting professor in international arbitration law at King's College London. He regularly lectures and publishes on international arbitration and commercial law. Mr Moollan has also made an immense contribution to the development of international arbitration in Mauritius, including drafting the nation's international arbitration statute and hosting the ICA Congress in Mauritius in 2016. We are all very anxious to hear what Mr Moollan has to say, so on behalf of Clayton Utz, without further ado, I warmly welcome our speaker, Mr Moollan.
Thank you very much, Frank, for this introduction, and good evening to you all in Australia. It is a pleasure to be delivering this 20th annual Clayton Utz lecture, and I thank Frank and his team, as well as Professor Chester Brown of Sydney University, for inviting me to do so. I'm joining you today from the Peace Palace in The Hague, where I'm currently participating, believe it or not, in a physical hearing. Those still exist, and it is a happy coincidence that I am in The Hague, for this lecture is based on research I have conducted and material I have prepared for a series of lectures this summer for the Académie de droit international de la Haye on the topic of parallel proceedings in international arbitration. The topic is a well-trodden one. Indeed, one could say it is one of the classical problems of international arbitration. There have, however, been major developments in practice since the last major academic consideration of the issue in 2006. And it seemed to me the time was ripe to revisit the issue through a fresh theoretical analysis and a renewed search for practical solutions. The structure I'm going to follow today replicates that I ended up using for the Hague Lectures. I will start with an attempt to define the topic and to create a typology of parallel proceedings, which will assist us in distinguishing parallel proceedings which are problematic from those that are not. I will then address in three main types of parallel proceedings. First, those which involve national courts on the one hand and an arbitral tribunal on the other. Secondly, those before two or more arbitral tribunals, but in a purely commercial setting, so with no investment arbitration element. And thirdly, parallel proceedings where there is such an arbitration element and where two or more arbitral proceedings are involved. I will then conclude by considering what practical solutions there may be to the problems we find. Let's start with the definition of our subject. What do we mean by parallel proceedings in international arbitration? There's no official or formal definition of parallel proceedings in international arbitration in legal instruments, treaty, or statute. Rather, it's an expression that has been coined in works of scholarship and commentary. The term parallel proceedings is not the only one used to refer to the same or similar phenomena. In English, other terms used include concurrent, multiple, and multi-party proceedings. In French, parallel proceedings are variously referred to as action pendante, concurrente, multiple, or connexe. Now, that French term, connexe, is particularly interesting because it does not appear to have a real equivalent in the English-speaking arbitral literature, at least not one that would be in common use. It can be translated as related, interrelated, or connected proceedings. There are more than mere differences of nuance or connotation between these different terms. First, the term parallel or concurrent proceedings, in French pendante or concurrente, put the emphasis on the time element. It means that the proceedings are progressing more or less simultaneously, that they are overlapping in time. These terms are inspired by and probably derived from the notion of dispendence. They are not entirely satisfactory. The time element fails to cover the full complexity of scenarios we're seeking to deal with, which go well beyond dispendence. Secondly, multiple and multi-party proceedings, in French multiple or multipartite, focus on the multiplicity of proceedings or of parties. But they don't address what these multiple proceedings should have in common to be grouped together under the same label. Thus, if the terms parallel or concurrent proceedings appears to be too narrow, the term multiple proceedings appears to be too wide. Thirdly, the terms related, interrelated, or connected, in French connexe, as I said, are interesting. These terms have greater currency in French than in English. In English, they're not used nearly as often as the terms I've just cited, perhaps because they're considered as nondescript. Yet, they do appear to be more apt than any of the preceding terms for the following reasons. They don't include a time element. They do not require simultaneity. The proceedings can be related, even if they do not move forward in parallel, or even if they don't happen at the same time. So those terms are rightly broader than the terms parallel or concurrent. Connexe is also not as broad as multiple or multi-party. It provides an important additional clue as to what should count as parallel proceedings proper. It is not enough to simply have multiple proceedings. It must also be the case that these proceedings are related or connected in some fashion or other. The French term connexe and its English translations are thus more accurate in that they place the focus on both defining attributes of parallel proceedings, and not just one of them, the multiplicity of proceedings and the connection between them. The only remaining task for purposes of defining parallel proceedings is to distill the nature of this connection. In other words, what kind of connection is required between multiple proceedings for them to qualify as parallel proceedings proper. The search for a working definition can draw on broadly two existing definitions. The one proposed by the ILA 15 years ago in 2006, and the one you can find, albeit indirectly, under Section 9 of the Brussels I regulations recast dealing with parallel proceedings pending before EU national courts. But both these definitions are centered on the classic notion of dispendence. As a result, they're both too narrow, leaving out modern-day scenarios that one would now consider to be instances of parallel proceedings, especially in the realm of investment arbitration. Ultimately, the working definition which I ended up proposing to the Hague Academy students is as follows. You're going to see it on screen. And I'm not going to read it out since you can read it for yourselves. This two-part definition reflects the complexity behind the concept of parallel proceedings. On the one hand, there must be an essential core, a minimum threshold below which one cannot genuinely speak of parallel proceedings. It is the line dividing parallel proceedings from separate proceedings with some similarities. On the other hand, above this threshold, the concept is not black and white. Rather, it's capable of semantic gradation and will depend on the specific circumstances of each case. The first part of the definition thus sets out the defining qualities of parallel proceedings, while the second part seeks to introduce the requisite degree of nuance and discretion. This working definition covers, I think, all the various scenarios that arise in the field of international arbitration today, notably in the field of investment arbitration, in which the subject of parallel proceedings has taken increased significance over the past few years. There are three classic scenarios that are covered by this working definition. The scenario of claims based on contracts against claims based on investment treaties. The scenario of so-called vertical claims, where shareholders at different levels of the same corporate chain bring claims against the same state based on the same key facts or state measure. And the scenario where investors with no link of ownership between them bring claims against the same state based on the same key facts or state measure. Now, before turning to the three types of parallel proceedings I mentioned in my introduction, let me make two further points on categorization. First, to categorize parallel proceedings, one may use two concurrent criteria. A first, objective one, based on the forum of the parallel proceedings, and a second, more subjective, but nonetheless important one, based on the purpose or motivation behind the parallel proceedings. There can be a wide array of reasons for bringing parallel proceedings: to ensure that a forum with jurisdiction is secured, where legitimate doubts arise as to the correct forum, to secure a tactical advantage, to vex proceedings one may not wish to defend, or to harass the other side. The perceived legitimacy of these motivations will be an important factor in how one in turn seeks to deal with the parallel proceedings in question. Secondly, it is also important, if one is to search for practical solutions, to analyze why and when parallel proceedings are considered to be problematic. Parallel proceedings pose a number of problems and challenges, both for the parties themselves, as I would describe as case-specific problems, as well as for the system of international dispute settlement as a whole, so systemic problems. One can list, firstly, inefficiencies, wasting time and costs. Secondly, the use of parallel proceedings as a tool for harassment. Thirdly, and probably most importantly, the risk of inconsistent and contradictory decisions. And fourthly, the fact that parallel proceedings and the risk just mentioned of inconsistent decisions undermines the confidence in arbitration as a system of adjudication as a whole. The challenge is to minimize these problems as much as possible, yet not all parallel proceedings are necessarily objectionable. Some will just be manifestation of a system operating as it should. The aim should accordingly be, first, to find means of distinguishing the two, so as to identify undesirable parallel proceedings, and two, to propose practical solutions to address those undesirable parallel proceedings. Let us now turn to the three areas where parallel proceedings can arise. Starting with parallel proceedings involving national courts on the one hand and international arbitration on the other, this is the first and perhaps most quintessential type of parallel proceedings. This is also the scenario most likely to occur in practice because it has the potential to arise whenever a dispute is submitted to arbitration, be it commercial or investment. Because irrespective of the theory of international arbitration one adheres to, and I'm referring here, I don't have time to go into it, to the three theories of arbitration proposed by the late Professor Gaillard in his Hague lecture, national courts have jurisdiction by default to adjudicate upon any dispute which parties have not agreed to submit to arbitration. When the parties agree to submit a dispute to arbitration, they introduce an exception to the default rule of national court jurisdiction. So what happens if it's not clear whether they have agreed to submit a specific dispute to arbitration? What if there is a grey area as to what falls within the scope of the arbitration agreement? This is, of course, one of the oldest classical problems in international arbitration. It has the potential to give rise to parallel proceedings, and often does so. The basic consensus on how to deal with this problem is embodied in an internationally accepted principle, that of competence. I'm not going to cover the doctrine of competence today. It is well known, I'm sure, to all of you. I would simply highlight that the doctrine has two facets, a positive one, which is almost universally accepted, and a negative one, which has only been adopted in a few jurisdictions. In its positive form, competence simply confers jurisdiction on an arbitral tribunal, the jurisdiction to determine its own jurisdiction, subject to control, usually de novo control, by the supervisory court of the seat. It is accordingly a potential source of parallel proceedings, since the tribunal is empowered to determine an issue which the supervisory court also retains ultimate control over. And it says nothing per se about how such parallel proceedings between the arbitral tribunal on the one hand and the court on the other are to be regulated. The negative facet of competence on the other hand seeks to address that question by providing essentially that the tribunal will always go first to the exclusion of the court. As I just noted, that pragmatic rule has so far not been adopted by many jurisdictions. France is the most prominent exponent of it, and it's also been adopted in Mauritius, where we adopted it with some limited exceptions. By contrast, if you look at the regime which applies in England, it is, with respect, unbelievably complex. You need to go to 5 different sections of the Arbitration Act in order to determine how to deal with this issue, and it gives rise, of course, to a lot of litigation and inefficiencies. The allocation of jurisdiction between courts and tribunals on the issue of the tribunal's jurisdictions is thus part of the ordinary course of business in international arbitration. There is nothing intrinsically pathological about it. Yet what must be noted is that the choice of doctrine of competence, whether you integrate negative competence or not, will have a direct impact on the potential for and the risk of parallel proceedings. Importantly, however, whatever the solution adopted, the risk of inconsistency is inexistent. It is universally accepted that the ultimate arbiter of jurisdiction is the national court. Any determination of jurisdiction by the arbitral tribunal is subject to review by the national courts. To the extent that parallel proceedings are considered undesirable per se, the only possible answer is to adopt a version of the negative facet of competence, be it in the French version, the Mauritian version, or any other one. Yet, to date, as I mentioned, only a handful of jurisdictions have done so. And this must mean that the risk of parallel proceedings lurks behind most interactions of national courts and arbitral tribunals on the question of arbitral jurisdiction. I now turn to the second category in our typology of parallel proceedings, that is the interaction between international arbitral tribunals in the context of purely commercial arbitrations with no investment arbitration element. Prime examples of such purely commercial disputes are building disputes, which will often involve parallel arbitrations between, say, a project owner and the main middling contractor on the one hand, and that main contractor and one or more of its subcontractors on the other hand, or insurance disputes, which will often involve parallel arbitrations between, on the one hand, the insured and its insurer, and on the other hand, that insurer and its reinsurers. In the first type of parallel proceedings we've just covered, courts against tribunals, the problem is inherent in the nature of international arbitration. Courts and tribunals are meant to interact. It is not a question of whether, but of how. That is not the premise in the second major type of interaction resulting in parallel proceedings, tribunals against tribunal. Whether the parallel proceedings are two commercial tribunals, one commercial and one investment, or two investment tribunals. In that situation, the question must first and foremost be whether, and then only how. For this reason, parallel proceedings are on the whole deemed to be more acceptable and less problematic in our first scenario, court against tribunal, than in the second I'm now addressing, tribunals against tribunal. The mechanisms that have been used to seek to minimize parallel proceedings in the commercial arbitration field mirror those which have traditionally been used by national courts to deal with such situations. They include the doctrine of lis pendens, to give preference to one set of proceedings, normally the first in time, over another. The doctrine of res judicata, to give binding effect to the award and findings of one arbitral tribunal, thus also discouraging the pursuit of parallel proceedings which could have led to inconsistent results. And the consolidation of parallel proceedings and the joinder of parties into existing proceedings. Those mechanisms cannot, however, simply be transposed into the field of arbitration. In particular, the cornerstone of arbitration, party autonomy and consent, are, in the words of Professor Klaus-Peter Berger, its natural weakness when it comes to joinder and consolidation. The English Court of Appeal described the problem as follows in Lincoln against Sun Life, an insurance case of 2004, which dealt with questions of issue estoppel. And the passage I'm going to quote to you is by Lord Justice Mentz, as he then was, at paragraph 68 of the judgment. Arbitration is, in contrast to litigation, a consensual private affair between the particular parties to a particular arbitration agreement. The resulting inability to enforce the solutions of joinder of parties or proceedings in arbitration, or to try connected arbitrations together other than by consent, is well recognized. Different arbitrations on closely interlinked issues may, as a result, lead to different results, even when, as in the present case, the evidence before one tribunal is very largely the same as that before the other. The arbitrators in each arbitration are appointed to decide the disputes in that arbitration between the particular parties to that arbitration. I just pause here to say, bear that in mind when we come to the question of investment arbitration. The privacy and confidentiality attaching to arbitration underline this. And even if they do not lead to non-parties remaining ignorant of an early arbitration award, they are calculated to lead to difficulties in obtaining access and about the scope of any access to material relating to the award. End of quote. And similar remarks were made by Lord Justice Longmore at paragraph 83 of the judgment. Thus, while the legal tools of lis pendens and res judicata remain available in principle to manage parallel proceedings in commercial arbitration, one should be conscious of the very serious limitations which their application encounters in practice. I will not cover the doctrines of lis pendens, res judicata, and issue estoppel today. These concepts are again well known to all of you. I will say a word about abuse of process and about consolidation. Starting with abuse of process, this may be a promising avenue to manage parallel proceedings in a way which is not limited by the stringent requirements of res judicata and issue estoppel. Common law jurisdictions have long developed it as a more flexible tool to deal with situations which do not fall precisely within the triple identity test required by these doctrines. In particular, it has long been established that in certain circumstances, one, a party may not seek to relitigate with a third party issues already litigated and determined in prior litigation in which it was involved, and two, that a party may not bring a new suit to litigate issues connected to prior litigation, which ought to have been brought and tried in that prior litigation. And what I've done, so as not to lose too much time, is I've placed a number of excerpts from leading English cases on the next 3 slides, which are going to be displayed for a few seconds each, but I'm not going to cover now. That doctrine, abuse of process, applies to protect the finality of arbitral awards just as it does to protect the finality of court judgments. And that important point is clear now as a matter of English law from the decision of the Court of Appeal in Michael Wilson and Partners Limited against Sinclair, which is a decision of 2017. So as I say, that is a potentially promising avenue because you're then free from the shackles of the triple identity test and can craft a remedy that will deal with the particular circumstances of the case. What about consolidation? The problem is that consolidation will only be possible where there exists a legal foundation for the same, which has to be applicable to all relevant sets of proceedings, and which importantly must do two things. First, it must record the disputing party's consent to consolidation ex ante, before a dispute actually arises. This ex ante consent obviates the need for ex post consent to consolidation at a time when tactical or other considerations may mean that it will not be forthcoming. Thus, for example, as part of the now superseded NAFTA arbitration regime, Article 1126 provided that a disputing party had the right to request consolidation with other NAFTA claims, and I quote, that have a question of law or fact in common. Thus, a party which contracted into the NAFTA regime expressly accepted the risk ex ante that consolidation may be ordered against its post-dispute wishes. So that's the first thing you need to provide for. Consent, ex ante. Secondly, the legal foundation must provide a workable mechanism by which consolidation may be brought to fruition, even in the face of opposition to it. In the case of NAFTA, Article 1126 makes this possible through the creation of a super tribunal. That's not an expression which is found in the old NAFTA, but which has been used by commentators. And that super tribunal will be in charge of hearing the consolidation request and had the power, inter alia, to divest previously constituted tribunals of their jurisdiction, either partially or completely, and to stay the proceedings of previously constituted tribunals pending its decision on the consolidation request. With the example of NAFTA, the two prerequisites are dealt with at the highest possible level within the treaty, which creates the party's right and duty to arbitrate itself. Conceptually, these prerequisites can be set out at a number of levels. So if we go back to the commercial sphere, there are three possible places where this could be recorded. Firstly, within the party's specifically negotiated arbitration clause itself. Secondly, in arbitration rules chosen by the parties. And thirdly, in the lex arbitri itself, which may make provision for consolidation or joinder by A, tribunals, or B, the courts. And I've given you examples of these three scenarios in the slides we now come to. So specific arbitration clauses, as I've put on our slide 5, there is anecdotal evidence of very long and complex clauses negotiated, for instance, in building projects. Now, this is not a viable solution for the vast majority of situations, and it has the disadvantage of recording the prerequisites of ex ante consent and practical means at the lowest possible level. In order for those to apply, the relevant party will need to be a contracting party to the specific agreement to suite of agreements. Within arbitration rules, we now have, I've just given you two examples. That's the next slide. You've got LCIA rules 2014, Article 22.1, 8 to 10. You've got the ICC rules 2021, Article 7 on joinder and Article 10 on consolidation. So that can be done at the level of rules. Within national legislation, you do not have that many examples. Section 2 of Schedule 2 of the New Zealand Arbitration Act 1996 does have a provision. We've taken this as an example for Section 3B and Schedule 1 of our Act in Mauritius, which is an opt-in procedure, so that will only apply if the parties have opted into it. And I've given you also as a third bullet point on that slide the odd development in US court practice, which has now been abolished, where the court decided, well, even without consent, we can do this, which did seem to go against the grain of what arbitration is about and has now been abandoned. Let us now turn to the third and last category in our typology of parallel proceedings, disputes involving an investment arbitration element. Just like with the first subgroup in commercial arbitration, the tribunal against tribunal interaction in investment arbitration does not represent a normal state of affairs. Investment tribunals are not designed to operate in tandem in the way courts and tribunals are designed to under the competence doctrine. But there are important differences between these two subgroups, commercial and investment. First, and perhaps foremost, there are special sources of parallel proceedings in investment arbitration. These sources make the problem of parallel proceedings prima facie more severe in investment than in commercial arbitration. Secondly, investment arbitration by definition involves states or state entities, and this renders the problem of parallel proceedings both more pressing, as it involves public funds, and more visible, as investment arbitrations are more often publicized. It is therefore no surprise that the hallmark case of parallel proceedings, the one that everyone always comes back to, was in an investment context, and that is, of course, Lauder against Czech Republic and CME against Czech Republic. These cases expose in a very public manner the glaring inconsistencies of two high-profile tribunals, and an outcome which no legal system fit for purpose should allow. The same dispute resulting in two diametrically opposed outcomes. In one, the Czech Republic was found not to be liable. In the other, it was found liable for hundreds of millions of euros. The Lauder CME saga was not an isolated event. The first decade of this century saw an explosion of investment arbitrations unlike anything that had been seen up to that point. The 2001 Argentine crisis generated dozens of investment arbitration over the same state measures, the so-called pacification of foreign-owned utilities and other tariffs that have been calculated in US dollars. This in turn formed a flurry of academic activity, articles, seminars, and events devoted to the subject. The prologue to the 2006 final report of the Geneva Colloquium on Consolidation in Investment Arbitration observed that, I quote, Argentina's financial crisis is the foremost recent illustration of the phenomenon of parallel proceedings. It then added that the crisis had by then generated 37 ICSID arbitrations. Even with the benefit of 15 years of hindsight, this is still a very heavy caseload to emerge from one crisis. Crisis in other countries likewise spawn scores of investment claims. According to UNCTAD data, Argentina remains today the country that has most often acted as respondent in investment arbitration with 62 cases. They follow Venezuela, 54, Spain, 53, the Czech Republic, 41, and Egypt, 40. Why has investment arbitration proven to be such fertile ground for parallel proceedings? The answer is that there are sources of parallel proceedings that are specific to investment arbitration, three of which have taken particular prominence. First, the factual matrix of an investment claim will more often than not include one or more contracts with their own arbitration or jurisdiction clause. Secondly, investment arbitration gives rise to the problem of so-called vertical claims, where multiple investors from the same corporate chain bring separate claims against the same state over the same dispute. I referred to that a moment ago. And thirdly, situations will often arise where the same state measure spawns numerous claims in arbitration from different investors with no links of ownership. These situations will not routinely arise in commercial arbitration. If you take each of them in turn, first, in commercial arbitration, there is typically but one normative source for the claims, contracts. No question will arise over how a public international law claim under a treaty and a private law claim under a contract should interact. Secondly, in commercial arbitration, there is no real risk of vertical claims. The contract will have one or more parties on each side, and claims will typically be brought by one set of parties against another within the same arbitration. Questions may arise, for instance, as to whether a non-signatory to the contract is also bound by the arbitration clause, potentially raising issues such as the operation of the so-called group of companies doctrine. But those will typically be resolved by one mandated tribunal or a national court when negative competence does not operate. By contrast, vertical claims are about linked claimants bringing separate claims against the same respondent, often under different treaties. And thirdly, in commercial arbitration, it would be most unusual for a single action by a party to result in a wave of separate arbitrations from unrelated claimants. By contrast, a single state measure has the potential to give rise to just such a scenario, as has happened in the investment arbitration sagas involving Argentina, Spain, the Czech Republic, Ecuador, Venezuela, where a single state measure affected a whole class of investors. The only scenario that bears a resemblance in commercial arbitration is so-called contracts of adhesion, that is, where one side dictates all of the contract terms, as happens, for instance, in consumer or employment contracts. But there are important differences between those two scenarios. Investment arbitration claims are usually high in value and thus can be brought as standalone claims, whereas contracts of adhesion claims from consumer or employees are often low in value and thus unviable as standalone arbitration claims. Many legal systems, in fact, prevent or regulate the bringing of arbitration of consumer arbitrations, the arbitration of consumer contracts or employee contracts. Also, in investment arbitration, the investor has a range of options to bring claims, national courts, or arbitration under different treaties and different rules that are absent in adhesion contracts. These three distinctive elements have something in common. They are all three expressions of what Jan Paulsen famously referred to as arbitration without privity, just over a quarter of a century ago. In investment arbitration, states make open-ended arbitration offers to an open-ended class of investors, and for this reason. First, investors which have signed contracts with the state can in addition rely on these treaties as a source for claims. Secondly, investors who are part of the same corporate chain have the ability to bring separate vertical claims over the same measure or facts. And thirdly, a single state measure can impact the treaty rights of a whole class of unrelated investors and thus result in a wave of investment claims. This makes investment arbitration fundamentally different from commercial arbitration. As Jan Paulsen wrote in 1995, investment arbitration is not just a subgenre of the existing discipline of commercial arbitration. Rather, treaty-based investment arbitration is, as he put it, dramatically different from anything previously known in the international sphere. This dramatic difference, which remains to this date, lies at the root of the problem of parallel proceedings in investment arbitration. It explains why this problem is far more acute in that field, and why the traditional solutions from commercial arbitration, lis pendens, res judicata, post-dispute consolidation, have so far been even less effective to address the problem in that field. On the undesirability scale, the Y classification typology, parallel proceedings against states, especially when they are perceived to be abusive or unfair, rank very high indeed. There are two main reasons for this. First, on the side of states, or at least some of them, there is a sense that states did not quite understand some of the potential implications of investment treaties when they signed up to them. As Jan Paulsen put it, when the field was still in its infancy, in the very last paragraph of the seminal article of 1995 I was referring to a moment ago, he observed there that the future of investment arbitration was to depend on how states would react to it, noting, I quote, that many national governments may not have appreciated the full implications of the new treaty obligations in investment treaties. Secondly, on the side of investors, or at least some of them, there is a sense that they ought to be free to use the system that was built for them, in whichever way works for them. which can be contrasted with state's view that such use should be limited in certain circumstances, and in particular, that by bringing parallel proceedings, investors are abusing the system to their advantage and to the detriment of states. Those features and others have caused a so-called backlash against investment arbitration. As noted by Professor Walid Ben Hamida in a survey conducted a few years ago, the problem of parallel proceedings played a substantial role in this development, and it is also central to the calls for reform, which have since been made within the UN system at UNCITRAL, and which I will turn to in a moment. This underscores the significance of the subject matter. If the future of investment arbitration hinges on national attitudes towards this field, and if parallel proceedings have the potential to start these attitudes, then it follows that the future of investment arbitration may depend in part on the system's ability satisfactorily to address the problem of undesirable parallel proceedings. I don't have the time to cover today the main sources of parallel proceedings in investment arbitration, which I've referred to so far. Just to remind you, the first, interrelationship between contract claims and treaty claims. Secondly, the question of vertical claims. And thirdly, the issue of multiple claims arising from the same state measure. It's something that I have tried to do within the Hague Lectures, but which would simply be too time-consuming. I have just referred to one jurisprudential development, which arose in Orascom against Algeria, where for the first time an investment tribunal barred a claim on the basis that the bringing of vertical claims was an abuse of process. As I said, abuse of process may have the flexibility that the traditional doctrines have lacked so far to deal with this issue to an extent. Now, where to from here? Let me turn to that, the search for practical solutions. Why are new solutions required? As we saw, the problem of parallel proceedings was the subject of substantial doctrinal and scholarly efforts in 2006. That year saw two important developments in this area of study. First, the 2006 alia recommendations on lis pendens and res judicata in international arbitration. That's alia Resolution 1 of 2006. And secondly, the Geneva Colloquium on the consolidation of proceedings in investment arbitration, which I referred to a moment ago, which gave rise to a substantial amount of travaux. These developments have provided a useful analytical framework and a basis to act for tribunals seeking to actively manage those issues. Yet, as we have seen, not much practical progress has been made in 15 years that have since elapsed. First, the classical solutions proposed, lis pendens, res judicata, consolidation, have been of limited assistance to deal with the problem of parallel proceedings efficiently, systematically, and across the board. These classical tools are helpful solutions, but will rarely apply in a field as fragmented as international arbitration, where each dispute is adjudicated upon by a specially constituted tribunal, albeit often under institutional oversight. New and more ambitious solutions should be sought. Secondly, the problem of parallel proceedings has taken on added significance and a different shape in the field of investment arbitration, and this clearly calls for action. So what more could be done? Given the time available, I will again only focus on the current efforts to reform the ISDES system. There are promising developments in the commercial field as well, particularly with respect to consolidation, where the rules of the main institutions have evolved considerably over the past 15 years, properly to grapple with the issue, and where the Singapore International Arbitration Centre, SIAC, has recently proposed a cross-institution consolidation protocol, which would allow consolidation across institutions. But I would not have the time to do those justice. Let me thus stay within the realm of ISDS, investor-state dispute settlement. As we have seen, investment arbitration is truly the field where the problem of parallel proceedings has acquired a new dimension. posing new, serious challenges that are as intractable today as they were when they first became apparent nearly 2 decades ago. That aspect and the threats to the consistency and coherence of the ISDS system that go with it have been a central symptom and feature of the so-called backlash or crisis of legitimacy that has faced ISDS for the past few years. That term, crisis of legitimacy, or those terms, I should say, crisis of legitimacy, backlash, have now been used for some years to describe the increasing lack of confidence which those outside the ISDS system, and a few inside it, have in the system. It has given rise to concrete action, perhaps most notably in the work of UNCITRAL, in the field of transparency, which I had the privilege to chair. I don't have time to cover this in detail again this afternoon, but would draw out the following points. 3 points on the work of UNCITRAL on transparency. First, the manner in which UNCITRAL had to start work in this area is instructive. The transparency project did not come to UNCITRAL in the usual quiet manner as a topic calmly picked by the Commission for future work amongst an array of other topics. It was brought to the fore forcefully by certain states, by NGOs, and by the then UN Special Representative for Business and Human Rights, Professor John Ruggie, in the course of UNCITRAL's work on what became the UNCITRAL Rules 2010. And the Commission had no choice but to agree to immediate work in the area with a specific focus on ISDS in order to preserve the integrity of the generic UNCITRAL rules as a set of universal rules applicable to both commercial and investor-state arbitration. Because what these proponents of transparency were asking for was for the generic rules to be broken into a set for commercial arbitration and a set for investment arbitration. Tellingly, and just to understand, I think, the psyche that underlies the current debate about reform, many arbitration practitioners immediately met the NGOs and Professor Ruggie's call for reform at the time with angry denial. And there was in particular, most notably, a letter from the Milan Club of Arbitrators putting in a written submission to that effect. That's the first point on transparency. Secondly, the manner in which the project concluded through the creative mechanism of a multilateral convention, the Mauritius Convention, which relies on the provision of Article 30 of the Vienna Convention on the Law of Treaties, to effect overall procedural reform affecting all existing investment treaties, provides a possible way forward for wider procedural reform going beyond transparency. Thirdly, following UNCITRAL's work, the calls for that wider procedural reform have become louder, and it has become increasingly clear in that forum, in UNCITRAL, that meaningful reform of the current arbitration-based ISDS system is necessary. It may well be that, as contended by those who operate within the system, a great deal of the criticism leveled at the system is misplaced, potentially unfounded, but 2 points appear difficult to escape. First, that those within the system have done nothing, or perhaps too little, too late, to reform the system. Many states now accordingly feel that the answer lies not with those internal actors, but with themselves, with sovereign states, to reform the system in a way which will retain its principal attributes, including, importantly, its neutrality, whilst ridding it of its perceived problems. Secondly, it ultimately matters little whether those problems are just perceived problems or real problems. Despite being a specialized and technical subject, ISDS finds itself in the mainstream news far too frequently nowadays, and always for the wrong reasons. On the front page of the New York Times, that was Bilcon, in Le Monde, in The Guardian, or in the London Times. So that a mechanism which was meant to depoliticize the settlement of disputes between investors and states has itself now become highly politicized, and is thus now arguably hindering rather than fostering trade and investment flows, as states that would otherwise welcome such flows run scared of the real or perceived legal risks that are now associated with them. Now, this clearly calls for reform. The question is how far those should go. As UNCITRAL has been debating that question over the past 3 years, it has clearly emerged that the main area of concern arises from the very nature of the current arbitration-based system, because that system relies on the ad hoc resolution of disputes by one-off panels. Fragmentation and the resulting lack of coherence and of consistency of solutions are hardwired in the system. That problem is exacerbated by the attitude of some, though not all, arbitrators who still come to the field with a commercial arbitrator's mindset and thus feel no duty whatsoever in upholding the systemic integrity of the system, but instead feel that their duty goes no further than to resolve the particular dispute which has been brought before them by these particular parties. Remember the words of Lord Justice Mance, which I quoted to you earlier in this lecture, in Lincoln, as to what is expected of commercial arbitrators. I quote again, the arbitrators in each arbitration are appointed to decide the disputes in that arbitration between the particular parties to that arbitration. That's perfectly fine for commercial arbitration, but that is indeed the mindset that some arbitrators are also bringing to investment arbitration, where things should be rather different. Now, the symptoms of that fragmentation are well known. As I noted earlier, our subject, the problem of parallel or concurrent related proceedings, is a key symptom. Despite numerous calls for action and some creative solutions devised inter alia by Professor Kaufman-Poehler based on abuse of process, they continue to plague the field. Another related symptom is that while some tribunals, again, and unfortunately not all tribunals, do strive to develop harmonized legal standards, the lack of any system of binding precedent or any mechanism to resolve conflicting authorities continues to prevent the emergence of legal clarity, thus enhancing the risk of inconsistency arising from parallel proceedings. The examples often referred to are the interpretation of MFN clauses or of umbrella clauses. But the problem is more fundamental. For it remains the case that for every treaty standard, fair and equitable treatment, full protection and security, expropriation, counsel on both sides of the dispute feel duty-bound to take every possible point, however tenuous, on the off chance that this particular panel of arbitrators, the writings of which have of course been carefully dissected prior to appointment, will reach a solution which departs from those reached by others and which will be favourable to their side. Now, that is not an efficient system of dispute resolution. Parties in contractual proceedings before domestic courts do not spend days arguing in every single contractual case on what consideration means if they are in England, or on the notion of cause if they are in France. The meaning of these notions have long been settled by the superior courts of the particular country, and the debate focuses on their application to the facts of the case in light of the specific language used in the contract in question. There is certainly no reason why one could not have settled principles governing the meaning of FET or FPS, always subject, of course, to the specific language used in the specific treaty, exactly in the same way as the specific language of a contract will be interpreted by a court. The question is thus no longer whether the ISDS system should be reformed, but rather how and how far. Some have been making the point that because the problems are systemic, they call for systemic solutions, and that no amount of incremental change will do. Others argue for retention of the current system, but with meaningful incremental change. These two ways forward are not antithetic, at least not in the short or medium term, as any systemic solution would take time to devise and implement. So that the path chosen by UNCITRAL has been to work in parallel, both on incremental and systemic reform. Let me now cover each of them briefly in turn. Starting with incremental reform, that is, changes to the existing system of arbitration-based ISDS, which otherwise preserve that system. Two areas of incremental reform are worthy of note, to which I would add, as with commercial arbitration, the question of whether one can expect a wider role for the doctrine of abuse of process. Forgive me. There is first the possibility of a very simple but potentially very effective soft law instrument in the form of a declaration by the United Nations General Assembly, similar to the interpretative declarations made by it regarding the New York Convention in 2006, coupled with a toolbox for parties and arbitrators. The second possibility is that of a cross-institution consolidation protocol, similar to that being promoted by TIAC in the commercial arbitration field. The first incremental reform tool which one might develop to assist is a soft law instrument directed at tribunals and parties, which would formally draw their attention to the differences between commercial arbitration and investment arbitration, and list a number of tools available to tribunals to coordinate parallel proceedings and minimize the risk of inconsistency between them, a so-called toolbox for parties and tribunals. The reason such a relatively simple instrument would be useful and potentially achieve much lies in the way in which the ISDS system was created and has developed. While arbitration, of course, has a long pedigree as a form of dispute settlement in the public international law arena, the fact is that in terms of procedure and personnel, investment arbitration has largely borrowed from the field of commercial arbitration. As a result, the reflexes and instincts of many practitioners in the field, be they counsel or arbitrator, are those one might expect from a commercial practitioner. Most notably, as I have already noted, a perception by arbitrators that their role, in line with that expected of a commercial arbitrator, is to serve the specific parties before them and resolve the specific dispute before them without any duty to the ISDS system as a whole or to any other interest. This can lead an investment tribunal, for example, to refuse to share information with another investment tribunal on the basis that it is privy to their proceedings and their proceedings only, notwithstanding the potential benefit in terms of consistency, or otherwise to refuse coordination. Yet it is now beyond doubt that ISDS is entirely different from commercial arbitration in that respect, and that the duties of arbitrators and the matters they should have regard to go well beyond the specific interest of the particular parties before them. Let me make that point good. That difference was the very premise of Antitrust's work on transparency in treaty-based investment arbitration, which resulted in transparency rules recognizing the legitimacy inter alia of amicus curiae briefs, of third-party intervention in proceedings, and of public hearings. And that was done by consensus of all United Nations states. It remains clear consensus of states at Antitrust and the very basis of the current reform efforts. So a simple but clear articulation of that difference between commercial and investment arbitration, calling upon tribunals to have regard to the systemic implications of their task and to the impact of their work on other parallel proceedings and on the integrity of the system as a whole, might thus go a long way towards facilitating coordination. A declaration by the UNGA to that effect, similar to that by which it regularly recommends its text from the model law to the arbitration rules, and similar to the formal recommendation which it has made with respect to the interpretation of Articles 2 and 7 of the New York Convention in 2006, would carry much weight and be difficult to ignore, even by the most commercial arbitration-minded tribunal. Turning to the second possible reform option, that a cross-institution consolidation protocol, as I noted a moment ago, CIAC is proposing such a solution in the commercial field, and there is some prospect that it could also be achieved in the investment field. A few points in that respect. First, all the leading institutions are represented in the Antitrust work and actively working with the Antitrust Secretariat, so that there must be real hope that such a protocol can be developed and agreed. Everyone is there and working together. Secondly, in the field of investment arbitration, it will be virtually meaningless for any given institution, whether ICSID, or UNCITRAL and the default nominating authority under its rules, the PCA, to make any attempt at consolidation provisions in their own rules alone. Most BITs give investors a menu of options as to which form of investment arbitration to access, so that investors minded to avoid consolidation could easily do so by choosing different rules for their claim. For example, ICSID for one, UNCITRAL for another, and Stockholm Chamber for a third. Thirdly, any such protocol between investment and arbitration-focused institutions may not address all issues, as they will often be related commercial arbitrations, as we have seen. Nor does the SIAC protocol appear easy to transpose into the investment arbitration field without adaptation, rendering the possibility of a single protocol dealing with commercial and investment arbitration somewhat optimistic. Last but not least, I come to possible systemic reform. The premise for the proponents of such a reform is that the reason why the current system is so fragmented is no random occurrence. The problem arises out of the very nature of the system, which of necessity creates a patchwork of independent tribunals created ad hoc to resolve each dispute as it arises, so that no amount of incremental tweaks can bring to the system the degree of coherence and consistency which any legitimate system of dispute resolution requires. Put differently, the problems that arise are systemic and require systemic change. As to the form which this systemic change should take, the main solution which is being canvassed at UNCITRAL is, of course, that of a multilateral court with a built-in appeal mechanism, which would finally resolve and settle conflicts of authorities. Such a court would in particular have the power to consolidate its proceedings and join parties, as any court does, and would produce judgments with res judicata effect at appellate level if required, which will have an impact not only on directly related claims, that is vertical claims, but potentially on other claims arising from the same measure or from similar facts. There is significant political support for such a solution from developing states and from the European Union, and significant opposition to it from other states. And it is premature to try and fathom what exact shape it will end up taking. Much of the resistance to the possible creation of such a permanent court system has been on the basis that while it may, in theory, resolve or alleviate many issues in the field, including that of parallel proceedings, it is bound to result in a system which will lack neutrality because it is being created by states and will thus favor states. That is not a premise which can be accepted at face value. The same persons that would reject the new court on that basis are themselves advocates of a system, the current ISDS system, which was created by states. Further, where the case for systemic reform is otherwise clear, it cannot be assumed that means cannot be found to ensure that the new proposed court system can't be devised in a way which will deliver the benefits of a coherent system while preserving neutrality. That is the task which currently faces UNCITRAL and which may contain the answer to many of the questions which I have sought to address in the course of this lecture, which now comes to an end. It has been a great honor and pleasure to deliver the same, and I thank you all for your attention.
It is now a great pleasure for me to give this vote of thanks to Mr Moollan, QC, for having addressed this year's Clayton Utz University of Sydney International Arbitration Lecture. In his lecture, Salim has tackled one of the great problems facing international arbitration, one of the great theoretical and practical difficulties, being how to regulate parallel proceedings in international arbitration in circumstances where the international legal order does not provide an obvious solution. In addressing this question, Salim has given us a comprehensive and analytical tour de force, and one which has provided us with theoretical nourishment and much practical food for thought. I'd like to express my thanks also to Frank Bannon and his excellent team at Clayton Utz for assisting with all of the organisational details of this year's International Arbitration Lecture. To my colleagues at the University of Sydney Law School, including our Dean, Professor Simon Bronnett. And most of all, thanks to Salim for his excellent and stimulating lecture. And I look forward to seeing you all again next year for the 21st instalment of the Clayton Utz University of Sydney International Arbitration Lecture. Thank you very much.